think she's decided to reshuffle the schedule and hear the gag order first?
I can come up with no other reason than she is purposely avoiding ruling on certain matters and doing the best she can to delay the trial of this cause as long as she possibly can. I just can't come up with a reason. If she is that ignorant of how to handle these matters, then she doesn't belong on the bench. If she's doing it because she's lazy, then she doesn't belong on the bench. And if she's doing it just to delay, then she doesn't belong on the bench.
Okay, so what would make you say that? What would be a more normal way to handle this?
Well, this case has basically been mishandled by her from the beginning, allowing Mr. Trump to file an action in civil court regarding a search warrant, which is criminal in nature and gets handled during the course of criminal litigation, was the first mistake. Twice she has been reversed by the 11th Circuit, and she's been chastised by them for, in essence, making decisions which are completely against the law, completely against pending precedent. So it really comes down to the point that I can come up with no other reason for this than she is doing this to purposely delay Mr. Trump's litigation.
There are many defendants who have legally challenged authority of special counsels. For example, Hunter Biden lost a challenge to the authority of special counsel David Weiss. Do you see this as different?
No, it is not different. And it goes all the way back actually to Paul Manafort when he was charged and he challenged the special prosecutor statute and the application of a special prosecutor. No court has ever granted this motion, and that includes multiple districts and a couple of circuits. So where she thinks that she is better than everybody else and knows this better than anybody else, that she needs the help of Ed Meese, of all people, to tell her what to do and allow someone who is not even involved in the litigation, has no dog in the fight whatsoever, to be involved in the litigation itself is completely unheard of. She is doing things just to do them. And she won't rule because she knows if there's an appeal on anything she rules on, the 11th Circuit would now have the ability on their own to remove her from this litigation.
If Cannon rules for Trump when it comes to the authority of the special counsel, I mean, is the case just done?
The case actually will require that the special prosecutor take an appeal, which will take things up to the 11th Circuit, and they will rule as every other court has ruled, and they will chastise her. And I believe that they would have no choice after the three rulings they've had to rule on, that the chief judge of that circuit would have no choice but to sua sponte remove her from this litigation. This is one of the reasons why she will not rule on anything, because she knows this could happen. That's the one intelligent thing that she's doing right now. And I'm going to use the words of the minority leader in the Senate, Mitch McConnell, when he was describing another judge candidate just recently, and said that that judge had distinguished herself with sheer incompetence. And I think I would use the same words to describe Judge Cannon.
Judge Jeff Swartz.
Not view this as having any real effect on that. It can around the margins, but not the core. So this isn't something that the Department of Justice is going to be freaking out about. Where you're wrong is when I said that Donald Trump could assert the Fifth Amendment in this civil proceeding. That is true. But there are consequences in a civil proceeding if you assert the Fifth Amendment. For instance, we saw that when Letitia James, the New York Attorney General, bring a case where Donald Trump assert the Fifth Amendment, that can be used against him. So if he had done exactly what you had said, just in a criminal case, and said, you know what, I don't have any burden. It's the government's burden to prove this case beyond a reasonable doubt. And, I don't have to do anything. That's totally right. And he can assert the Fifth Amendment and it cannot be used against him. Of course, if he wants to claim that these are planted, there needs to be some evidence that he would need even in a criminal case. But this is where, because this is a civil case, why Judge Dearie, in the very first hearing he held, said you can't eat your cake and still have it remain. And what he was saying there is, if you don't want to say anything, if you don't want to assert anything about these documents, that's fine, but there are consequences because the government has already put in prima facie evidence. That is, they've already made a showing of what these documents are. So I don't need any more proof. And if you're not going to speak up, then I'm just going to rule on what's here. And then the final piece, which is just a question of how tawdry the Judge Cannon is. I mean, this is the way she has treated a respected, far more experienced Article III judge who was selected by her and Donald Trump as the special master is really beyond the pale. It just shows she's just so unfit to be sitting on the bench. I mean, we already know from the 11th Circuit that her decision was wrong up one side and down the other. But now she's really proved that she really, I think, is just not showing any normal signs of decency to a fellow Article III judge who is so much more esteemed and experienced, with no deference at all when he is doing exactly what she had said he should be doing.
What do you think it'll mean to Judge Dearie going forward in the case?
I can surmise what he might be thinking right now, which is no good deed goes unpunished. I mean, this is not something he was looking to do. I think I'm sure, did this out of a sense of duty and obligation. It's an unusual position for an esteemed senior Article III judge to be doing this for a junior Article III judge. But I think he probably felt that it was something that the nation